Good morning, Mr. Watson. You can approach the mic.
Well, I have a question. I don't know how this hearing can proceed. I filed several motions and never received a response from this court.
Well, what we have in front of us at the moment are 5 separate proceedings that you began in the single justice session, and that the court has ruled that you have 10 minutes to discuss any of the issues in those cases. If there are motions that have been filed subsequent to when we agreed to hear this, they can be dealt with subsequently.
Well, I understand that would be rather difficult. One concerns the recusal of this panel. The other one concerns the violation of my due process and equal protection rights by ordering to argue 5 cases in 10 minutes, which is 2 minutes each case. And if there's any questions, then it takes even less time for my argument. There's also the concern of the lack of service of the brief from the Attorney General, its submission to the court. And I don't understand how I can argue 5 cases in 10 minutes since they're all distinct cases.
I understand that, but the court has made a determination that that's the amount of time they are. We set limits for every case, and some of them have many issues, and they get argued in 10 minutes or 15 minutes, and that's the way we do it.
Okay,
So make the best use of your time that you can.
Okay, I just put for the record I object based on violation of due process.
I understand that. Thank you.
I'll argue the issue that is most important.
Sure.
The constitutionality of 209A, Massachusetts Chapter 209A. I would argue that it violates the 14th Amendment in one category based upon the 5th Amendment. According to Chapter 209A, Section 7, the police are required to serve the defendant or the accused with necessary paperwork for the hearing. The decision made by this court in Flynn versus Warner is that the necessary paperwork concerned would only contain the summons and the notice of the hearing. It would not include the affidavit. In Frizzato versus Frizzato, this court, where there's confusion, is that it stated that an individual has the right to review the affidavit before the hearing. But this violates the 5th Amendment because an individual is entitled to know the charges against them, and it would violate Article 12 of the Massachusetts Declaration of Rights, as well as the 14th Amendment, the procedural due process rights, concerning the fact that 5 to 10 minutes to obtain information on a complaint in a hearing is insufficient time. It denies an individual the opportunity to obtain documentation as well as witnesses to challenge the accusations in the affidavit. Now, the greatest point about the Constitution, the most powerful point as far as argument, as far as the constitutionality of 209A is the violation of the due process clause. The U.S. Supreme Court has established test criteria using Matthews versus Eldridge. As stated in my argument, the first is the nature of the private interest. As a general application, the fact that an individual can be forced from the home violates the 4th Amendment. The fact that they can lose their employment if they're armed security, if they have they work at the same residences, same place of employment as the other individual, if they have a gun license, it violates the Second Amendment, especially after the D.C. versus Heller decision. So that first point weighs heavily in favor of the individual being accused, that it demands a higher standard of evidence than preponderance of evidence. The second is countervailing government interest for the state. It's true that the state has a great interest in addressing the issue of domestic violence in our society, our city, and our state. Unfortunately, the same argument can be said concerning the issue of child abuse, which in Santosky versus Kramer was addressed, and the U.S. Supreme Court determined that the standard of evidence in that matter should be at least clear and convincing evidence. Domestic violence is no greater an offense than child abuse. And the most critical one of the Eldridge criteria is the risk of error in the ultimate determination. This court has recognized in its opinion to the U.S. Senate, that there is a great risk for error because of false allegations. There has long been a accusation that the 209A, Chapter 209A is used as leverage in proceedings totally unrelated to the intent of the statute. Probate matters, vindictiveness due to lack of character, and there has been the concern that justices of the Commonwealth are more willing to issue a restraining order than to really scrutinize the testimony of individuals out of security for their position, and concerned that there will be ultimate scrutiny from the media if there are subsequent actions that happen that result in dramatic newsworthy items. The other issue to be addressed in the constitutionality is the failure of Chapter 208 to require judges to issue written specific findings. Again, it violates the Due Process Clause as well as the Equal Protection Clause. There have been various cases before the appeals court and this court in which the failure of the justice to issue written specific findings in a issuance of a restraining order were insufficient to offer enough information for the judges, for the appeals court to this court to issue a decision, and is remanded back to the district court. That means that in the meantime, the accused has to endure a restraining order, which I'm sure that individual argued was issued improperly and unconstitutionally. The fundamental requisite of the Due Process Clause is a meaningful opportunity to be heard in a meaningful time. That would not be a meaningful time if these delays arise and allow the person to be subjected. They have to endure an offense for which they would argue they are innocent. It would violate the Equal Protection Clause because there is a requirement under Section 3 of the 209A that written specific findings are to be issued when there are mutual orders. This puts the individual who doesn't have a mutual restraining order at a distinct disadvantage. The U.S. Supreme Court has determined that in various cases that the Equal Protection Clause basically says that all people in a similar situation are to be treated similar. And an individual who is the subject of a restraining order is in the same situation as the individual who issued one and is also a victim of a restraining order. There is no special governmental interest furthered by granting an individual who has applied for a restraining order and is subject of one, giving his actions more scrutiny than the individual who is merely the subject of a restraining order. Last but not least is the fact that the Commonwealth is applying undue pressure on individuals to overcome the 209A. It's been established in numerous cases. Specifically, you can look at the Dunn versus Blumstein case that I cited in my report. State statutes that affect constitutional protected rights have to be written with precision so as not to squash the constitutional rights of the individuals involved. If they have to be burdensome, a state must find the least burdensome way to encroach on that constitutional right. This is being hampered in the Commonwealth by the failure of the courts, the Chief Justice of the District Court, as well as Chief Justice of the Probate Court, and the Administrative Office of the Trial Court to provide statistical information on restraining orders that are issued. There is the accusation, and there's great credibility for it, that the 209A law is inherently being implied in a discriminatory manner against males. Unfortunately, the Commonwealth refuses to issue statistics on the number of ex parte orders issued, the number of orders that are extended after ex parte hearings, the number of orders that are extended after the first year, the number of orders that are issued for a permanent fashion, and as well as, more specifically, a breakdown of that based on the gender. There have been numerous cases, Commonwealth versus Laura, which came before this court, and others that said individuals should have the opportunity to gather information to show disparity that shows discrimination. And unfortunately, the common pleas in doing that. The failure to do that violates an accused, a defendant in a 209 proceeding violates his due process rights as well as his First Amendment rights, because he's not being given the full opportunity to prevent as much information, not only in his matter, but to show a trend as far as in his case in relation to others. That's all I argue. Any questions?
I don't believe so, Miss. I'm so sorry. Balakrishna, do you have any?
Very briefly, Your Honor, on behalf of the various state court judges, clerks, and court employees, the Attorney General's office would ask this court to affirm the various decisions of the single justice to dismiss Chapter 211, Section 3 petition, where Mr. Watson has not shown that his appellate remedy was inadequate.
Thank you.
Your brief says, and I will just ask you, that you did indeed certify, I mean, you have a certificate of service, that you did serve Mr. Watson at 3 different addresses. Is that, in fact, the case?
I did direct it
I mean,
to
I
be
don't mean to say
mailed.
that you personally did it, but I mean,
Yes,
I think it says that you put it in the mail to 3
We
different
did
addresses.
make 3 address labels for the 3 addresses that we did have.
Thank you.
Thank you, Your Honors.